Never say this one sentence to police. Not because you are guilty, not because you are hiding something, but because the system will remember your words longer than it remembers the truth. Most people believe police interviews are conversations. They are not. They believe honesty protects them. It does not. They believe explaining everything will clear confusion. It usually creates it. There is one sentence police want to hear more than any other. A sentence that sounds harmless. A sentence that sounds cooperative. A sentence that sounds human. I just want to explain what happened. This sentence has destroyed more innocent lives than most crimes ever have. Not because it is false, but because it opens a door you cannot close. The moment you say this sentence, you change your role. You stop being a citizen. You become a source of evidence. Police interviews are not about finding the truth. They are about creating a version of events that can survive court. Truth is messy. Court is not. When you explain, you give police raw material, words, timelines, emotions, contradictions, pauses. Everything you say becomes permanent. Your stress becomes suspicion. Your confusion becomes inconsistency. Your memory gaps become motive. Humans do not speak perfectly under pressure. Police know this. The system depends on this. A normal person believes, if I just tell them everything honestly, they'll understand. Police believe, if they keep talking, something useful will appear. These two beliefs collide, and the citizen always loses. Police interviews are designed environments. Lighting, seating, silence, tone, timing. Nothing is accidental. Officers are trained to listen selectively. They do not listen to understand you. They listen to extract leverage. When you begin explaining, they do not stop you. They encourage you. They nod. They reassure. They say, take your time. This is not kindness. It is strategy. The longer you speak, the more material exists. Material does not need to be true. It needs to be usable. Usable against you. The system does not correct misunderstandings. It records them. You might say something incomplete. Police do not complete it for you. You might say something unclear. Police do not clarify it. They preserve ambiguity, because ambiguity wins cases. This is why police rarely ask yes or no questions. They ask open-ended ones. Tell me what happened. What do you remember next? Why do you think that occurred? These questions are traps disguised as curiosity. Your brain tries to be helpful. It fills gaps. It smooths timelines. It guesses. Guessing is deadly in court, because later, when you speak differently, it looks like lying, not because you lied, because humans do not store memories like recordings. Police know this. Lawyers exploit this. Courts punish this. And it all starts with that one sentence. I just want to explain what happened. In that moment, you think you are helping yourself. In reality, you are helping the system build a case. This is not about bad police. This is about design. The legal system does not reward honesty. It rewards consistency. Consistency across interviews, reports, testimony, cross-examination. Most people cannot be perfectly consistent, especially under stress. This is why silence is powerful, not because it hides truth, but because it prevents distortion. Silence creates a problem for police. Talking solves it. This is why officers often say, if you didn't do anything wrong, why won't you talk? Because talking is not protection. It is exposure. Silence is not guilt. It is strategy. The system knows the difference. Citizens usually do not, and that ignorance is expensive. By the time people realize what happened, their words have already been written into reports, interpreted, reframed, and locked into the legal record. From that moment forward, the story no longer belongs to them. It belongs to the system. Police interrogation is not a conversation. It only looks like one. Most people walk into an interview room thinking they are about to talk. In reality, they are about to be studied, measured, recorded, and slowly boxed in. The room is small for a reason. The light is harsh for a reason. The silence exists for a reason. Nothing inside an interrogation room is accidental. When a police officer says, "Relax, we just want to talk," they are not offering comfort. They are setting a trap. Because conversations are equal. Interrogations are not. In a conversation, both sides exchange information. In an interrogation, only one side benefits from information. Police already have a theory. They already have a direction. They are not there to discover the truth. They are there to confirm a version of events that works. And your words are the raw material. When you begin explaining, the power shifts. You think you are clarifying. They think they are collecting. Every sentence you speak is recorded. Every pause is noted. Every hesitation is meaningful. Silence is not awkward to police. It is informative. When you hesitate, they mark it. When you rush, they mark it. When you change your wording slightly, they mark it. Not because you are lying, but because humans do not speak perfectly under pressure. Police are trained to create pressure. They ask open-ended questions on purpose. Tell me what happened. What did you do next? Why do you think that happened? These questions are dangerous. They invite guessing. They invite filling gaps. They invite assumptions. And assumptions are fatal in court. You might not remember a detail clearly, so you approximate. You say what feels right. Later, when evidence appears, your approximation becomes a contradiction. Police do not fix contradictions. They preserve them, because contradictions are leverage. Once leverage exists, the balance is gone. Another illusion is friendliness. Officers may smile. They may joke. They may act sympathetic. They may say they understand. This is not friendship. It is technique. A relaxed subject talks more. A relaxed subject makes mistakes. Police are not required to stop you from harming yourself legally. They are allowed to let you talk. And they will. Police reports do not record your emotions. They record interpretations. Your long explanation becomes a short sentence. Your context disappears. Your tone is replaced. What you meant is irrelevant. What was written becomes reality. By the time you see the report, it is too late. Your words are no longer yours. They belong to the system. This is why lawyers fear interrogations more than arrests. An arrest is a moment. An interrogation is permanent. Charges can change. Stories rarely do. Once a version of events is locked into the record, everything else must fight against it. And fighting the record is expensive, difficult, often impossible. This is why the most dangerous thing you can do is try to explain, because explanation creates material. Material creates structure. Structure creates a case. Silence creates uncertainty. And uncertainty scares the system. Police are trained for interrogations. You are not. The system knows this difference. It depends on it. And that is why police interrogation is not a conversation. It is a process designed to extract, not to understand. Words do not stay words. In the legal system, they transform. The moment you speak to police, your words stop belonging to you. They begin a journey. That journey turns language into evidence. Evidence does not care about intention. It cares about interpretation. When you speak, you think in meaning. The system listens for structure. You might say something casually. Police record it formally. You might explain emotionally. Police document it mechanically. You might speak to be understood. The system rewrites you to be used. This is how words change shape. First, your words are recorded. Audio, video, notes. Not everything. Only what matters to the case. Silence is rarely recorded. Context is rarely recorded. Emotion is almost never recorded. What survives is fragments. Fragments are powerful. Fragments can be rearranged. A sentence spoken at minute 5 can be connected to a sentence spoken at minute 40. The space between them disappears. Tone disappears. Stress disappears. Fear disappears. Only structure remains. And structure is persuasive. Police reports are not transcripts. They are summaries. Summaries are interpretations. An officer decides what is important, what is irrelevant, what supports the case, what is not. You do not approve this process. You do not see it happening. By the time you read the report, the story is already written. Your voice has been replaced. Another dangerous truth. Words do not need to be false to be damaging. They only need to be incomplete. You might forget a time, guess a distance, approximate an order. Later, Evidence fills those gaps. Your earlier approximation becomes a contradiction. Contradictions look intentional. Intent is not required. The system assumes consistency. Humans do not operate consistently under pressure. This gap is fatal. Courts do not ask, was this person stressed? They ask, why did this change? Once your words are labeled inconsistent, everything else you say becomes suspect. Credibility collapses. Another transformation happens quietly. Your words are separated from your control. Lawyers quote you. Prosecutors repeat you. Judges reference you. But you cannot re-explain. Clarifications are treated as excuses. Corrections are treated as lies. Your first version becomes the anchor. Everything else is compared against it. This is why police interviews happen early, before lawyers, before arrest, before clarity. Early words are messy. Messy words are useful. Another truth most people never hear. Police are allowed to misunderstand you. They are not required to resolve ambiguity in your favor. Ambiguity helps the case. If a sentence can be interpreted two ways, the version that helps prosecution survives. Not because of malice, because of incentives. The system rewards usable evidence, not accurate representation. Once your words enter the system, they are no longer evaluated as human communication. They are evaluated as legal tools. Tools do not feel. They do not explain themselves. They do not correct context. They are used. This is why silence is powerful. Silence creates no fragments. Silence creates no contradictions. Silence creates no anchors. Silence forces a system to work without you, and that is dangerous for them. Talking makes their job easier. This is why the sentence, "I just want to explain what happened," is not innocent. It opens the door for transformation, from citizen to subject to record to evidence. And once that transformation happens, you cannot reverse it. You cannot unspeak. The system does not forget. Most innocent people talk to police for one simple reason. They believe silence looks guilty. This belief is wrong, but it is powerful. From childhood, people are taught that honesty is protection. Tell the truth. Explain yourself. Clear the misunderstanding. That logic works in human relationships. It fails inside legal systems. Because the legal system does not operate on trust. It operates on risk. An innocent person feels urgency. They want the situation to end. They want to go home. They want the confusion cleared. Police understand this instinct. They rely on it. Innocent people talk because they feel safe. Guilty people talk because they feel trapped. The system treats both the same. Another reason innocent people talk is fear. The room is unfamiliar. The authority is real. The stakes feel high. Silence feels confrontational. Talking feels cooperative. Police are trained to reinforce this feeling. They say things like, "If you didn't do anything wrong, you should talk. Help us understand your side." Only guilty people ask for lawyers. None of these statements are about truth. They are about pressure. An innocent person wants to appear reasonable, so they speak. But reasonableness has no legal value. The law does not reward good intentions. It records outcomes. Another reason innocent people talk is social conditioning. People are uncomfortable with silence. Silence feels rude, suspicious, unnatural. Police are comfortable with silence. They use it. Long pauses, eye contact, waiting. Eventually, the human brain fills the gap. Talking relieves tension, even if it causes harm. Another reason is misunderstanding rights. Many people believe, "I can clear this up quickly. I can talk now and get a lawyer later. I'll explain first, then protect myself." This is backwards. Once words exist, protection arrives too late. Rights do not erase records. Another powerful force is authority bias. Uniforms, badges, institutional confidence. People assume authority equals fairness. But authority is not neutrality. It is power. Police represent the state. The state's job is not to protect you. It is to enforce law. This distinction is rarely explained. So innocent people cooperate with the wrong goal. They try to prove innocence. The system is not asking for proof. It is collecting leverage. Another dangerous belief. If I stop talking, things will get worse. In reality, silence slows the system. Slowness protects citizens. Speed protects institutions. Police prefer speed, fast statements, quick narratives, immediate records. Silence disrupts this flow. That is why silence is discouraged. Another factor is emotional shock. People are questioned during moments of stress, after accidents, after arguments, after trauma. Memory is unstable during stress. Innocent people fill gaps unconsciously. They guess, they approximate, they rationalize. Later, when clarity returns, their earlier words remain, and clarity looks like inconsistency. Innocent people do not expect this trap. They assume innocence is obvious. They assume truth is visible. They assume fairness is automatic. None of these assumptions survive court. The system does not care why you spoke. It only cares that you did. This is why silence feels unnatural, but is legally powerful. Silence is not defiance. It is protection. Innocent people talk because they trust the system. The system survives because that trust exists, and that trust is often misplaced. Not all confessions sound like confessions. Most of them do not. The legal system does not need you to say, "I did it." It only needs you to say enough. Enough to suggest presence. Enough to suggest knowledge. Enough to suggest opportunity. These are called partial admissions, and they are far more dangerous than full confessions. A full confession can be challenged. A partial admission quietly survives. When an innocent person explains what happened, they often say things like, "I was there earlier. I might have touched it. I don't remember exactly. I could be wrong, but..." None of these sound criminal. Legally, they are explosive because the system does not hear intention. It hears positioning. Being there earlier becomes proximity. Touching something becomes involvement. Uncertainty becomes unreliability. And unreliability becomes suspicion. Police are trained to guide people toward these statements. They ask questions that narrow options, questions that assume facts, questions that suggest outcomes. "You were there before, right? You touched it at some point? You probably didn't notice the time." Answering these feels harmless. Correcting them feels awkward. So people go along. This is called agreement bias. Humans prefer agreement over conflict. Police interviews are built around this. Once you agree to a small detail, the interview moves forward as if that detail is settled. Later, that detail becomes a foundation. Foundations support cases. Another dangerous form of non-confession is explanation. When people explain behavior, they often justify it. "I was angry. I was tired. I wasn't thinking. I didn't mean it." These sound human. Legally, they sound like motive. The system does not need you to admit wrongdoing. It only needs you to explain behavior in a way that fits a theory. Another trap is hypothetical language. Police ask, "What if?" "Could it be that?" "Is it possible?" When you answer hypotheticals, you enter imagination. Imagination is not evidence, but your responses become it. You imagine a scenario to be helpful. The system records it as possibility. Possibility becomes probability. Probability becomes argument. Another subtle confession happens through correction. Police intentionally misstate facts. "You got there at 9. No, it was closer to 8. You think you are correcting an error. Legally, you just place yourself at the scene earlier. Corrections feel safe. They are not. They anchor timelines. Another invisible confession happens through denial. When people deny strongly, they often over-explain. "I would never do that because..." Everything after "because" becomes material. The system ignores a denial. It studies the explanation. Police are not listening for innocence. They are listening for structure. They collect timelines, emotions, word choices, shifts. All of it builds a profile. Once enough structure exists, the system no longer needs your cooperation. You can stop talking. It no longer matters. This is why innocent people are shocked later. They say, "I never confessed." The system replies, "You didn't need to." Confessions are not always admissions. They are patterns. Patterns of presence. Patterns of behavior. Patterns of explanation. And once patterns exist, they are hard to erase. This is why silence is powerful. Silence creates no patterns. Silence creates no partial admissions. Silence creates no scaffolding for a case. Talking builds a case for them. Quietly, legally, permanently. This is how innocent people confess, without ever admitting guilt. Interrogation is not about asking questions. It is about applying pressure legally. Pressure does not look violent. It looks patient. Police are trained to create stress without force. They use time, silence, repetition, tone. Hours pass. Questions repeat. Details are revisited again and again, not to learn, to fatigue. Fatigue weakens memory. Fatigue increases compliance. A tired person grieves more easily. Police also control the pace. They rush you when it benefits them. They slow down when it benefits them. You never control the rhythm. Another technique is isolation. No phone, no familiar faces, no feedback from outside reality. Isolation magnifies authority. In isolation, police become the only reference point. When they say something feels reasonable, it starts to feel true. Another technique is certainty. Police often speak with confidence, even when they are unsure. They say things like, "We already know what happened. We have evidence. This is your chance to explain." These statements do not need to be true. They only need to sound final. Certainty pressures people to talk. Another method is normalization. Police may suggest that behavior was understandable. Anyone would have reacted that way. "I get why you were angry." This lowers resistance. Once resistance drops, explanation begins. Explanation creates material. Another common technique is repetition. The same question, asked slightly differently, again and again. Humans naturally change phrasing when repeating answers. These changes look like inconsistency. Inconsistency looks like deception. Another technique is choice framing. Police offer two options. Both assume guilt. Did you mean to do it, or was it an accident? Refusing both feels unnatural. So people choose the lesser option. Choice creates admission. Another technique is false urgency. Police imply consequences. This is your last chance. If you don't talk now, it gets worse. Urgency pushes mistakes. Mistakes become evidence. Police are allowed to lie during interrogations. They can misrepresent evidence. They can exaggerate certainty. They can invent witnesses. This is legal. Citizens are rarely aware of this. They assume honesty on both sides. That assumption is exploited. Another powerful technique is contrast. Police alternate between pressure and kindness. Harsh tone, then calm tone. This emotional shift disorients. Disorientation increases dependence. Dependence increases talking. Police do not need to threaten you. They need to outlast you. Interrogations are endurance tests. The longer they last, the more likely you speak. And once you speak enough, the case writes itself. This is why lawyers fear interrogation rooms. Not because of brutality, but because of design. The techniques are legal. The outcomes are devastating. And every one of them becomes powerful only after you decide to explain. That first sentence opens a door. Everything after is technique. What you meant is not what the court hears. Courts do not listen to people. They listen to records. By the time your case reaches a courtroom, your voice is gone. Your words arrive alone, cold, typed, separated from you. Judges do not watch the interrogation. Juries do not feel the pressure. They see reports, transcripts, summaries. These documents are treated as neutral. They are not. Every report is written by someone with assumptions, someone with a theory, someone with incentives. Your explanation becomes a paragraph. Your hesitation becomes a sentence. Your emotion becomes punctuation, and punctuation changes meaning. When a judge reads, "The suspect stated," they do not hear fear. They hear confidence. When a report says, "The subject admitted," they do not see confusion. They see certainty. Courts trust documents more than memory. Documents look stable. People do not. So when your testimony conflicts with the report wins. Not because it is true, because it is consistent. Consistency is the highest value in court. Truth changes. Memory evolves. Understanding deepens. The system punishes all of that. Another problem is legal framing. Prosecutors do not repeat your words randomly. They choose moments. They quote selectively. They repeat phrases. They isolate sentences. A sentence spoken once becomes central. Context disappears. The jury hears your words, but not your situation. They hear certainty, where there was none. Another distortion happens through questioning. Lawyers rephrase your statements. So what you're saying is, this phrase is dangerous. It replaces your language with theirs. If you agree, the new version becomes yours. If you disagree, you look evasive. Either way, control is gone. Courts do not analyze how statements were obtained. They analyze how statements fit the case. Pressure is rarely visible. Stress is rarely considered. Fatigue is rarely mentioned. Your mental state does not appear in the transcript. Only your words do. Another hidden issue is time. Statements are made early. Trials happen later. Months pass. Sometimes years. You change. Your understanding grows. But your words stay frozen. Growth looks like inconsistency. The system treats learning as lying. This is why lawyers avoid explanations. They know words travel forward in time. Without mercy, courts do not ask, why did this person say this? They ask, how does this help us decide? Decisions are built on structure. Structure is built on words. Once your words exist, they shape everything. Charges, plea offers, bail decisions, sentencing. The earlier the words, the heavier they weigh. And the earliest words come from interrogations. When you were tired, scared, unprepared. This is why the sentence, I just want to explain what happened, is not harmless. It creates a record the court will trust more than you. And once the court believes a record, your meaning no longer matters. Silence is the one thing the system cannot control. That is why it is discouraged. Police do not fear lies. They fear uncertainty. Silence creates uncertainty. When you stop talking, the flow of information breaks. The process slows. The narrative pauses. And the system hates pauses. Investigations are built on momentum, statements, timelines, connections. Silence removes momentum. Without your words, police must work harder. They must verify. They must corroborate. They must rely on evidence alone. Evidence is expensive. Words are cheap. This is why silence is framed as suspicious. You're not helping yourself. Only guilty people stay quiet. If you're innocent, talk. These statements are psychological tools, not legal truths. The law does not punish silence. The system pressures against it. Lawyers insist on silence for one reason. It protects future options. Silence does not close doors. Talking does. Once you speak, the system narrows possibilities. Charges form around statements. Theories solidify. Assumptions harden. Silence keeps paths open. Another reason silence is powerful. It prevents mistakes. You cannot contradict yourself if you say nothing. You cannot misremember if you do not speak. You cannot create timelines that later collapse. Silence creates no record, no fragments, no anchors. It forces a system to move without you. This is dangerous for institutions. Institutions prefer cooperation. Cooperation speeds resolution. Resolution reduces cost. Silence increases cost. More investigation. More time. More uncertainty. That is why silence is resisted. Another uncomfortable truth. Silence shifts power. When you speak, police control the direction. When you stay silent, they lose leverage. They cannot guide. They cannot reframe. They cannot rearrange. They must react. The system is not built to react. It is built to extract. This is why lawyers repeat the same advice. Say nothing. Ask for counsel. Not because lawyers want to delay justice, but because they understand timing. Words spoken early weigh the most. Words spoken later are strategic. Silence protects you during the most dangerous phase. The first contact. The first interview. The first record. Once a lawyer enters, the rules change. Questions become formal. Statements become deliberate. Pressure decreases. Silence buys time. Time buys clarity. Clarity buys protection. The system does not tell you this. It relies on urgency, on fear, on confusion. Silence breaks that cycle. That is why silence is powerful. Not because it hides truth, but because it preserves it. The system can work without your words, but it works best with them. So it pushes, it pressures, it persuades. And the moment you resist, the imbalance becomes visible. Silence is not defiance. It is self-defense. And in a system built on records, the absence of a record can be your strongest protection. The damage caused by that one sentence does not happen immediately. It happens quietly, over time. Most people expect consequences to be obvious, an arrest, a charge, a clear moment when things go wrong. That is not how this works. The real impact appears later, in patterns, not moments. First, your words influence how police classify the case. What might have been unclear becomes suspicious. What might have been unknown becomes explained. Your explanation gives shape to uncertainty, and shaped uncertainty becomes theory. That theory follows a case everywhere. It influences how detectives investigate, what evidence they prioritize, what evidence they ignore. Once a theory exists, confirmation bias takes over. Investigators look for proof of the theory, not alternatives. Your words become the lens. Second, your words affect charging decisions. Prosecutors do not start with facts. They start with narratives. They ask, can we prove this story? If your statements already support a version of events, charging becomes easier, not because the case is stronger, because the story is clearer. Third, your words influence bail and detention. Judges consider risk, flight risk, danger, credibility. Statements that appear inconsistent raise risk. Explanations that sound emotional raise concern. Silence rarely increases risk. Talking often does. Fourth, your words shape plea negotiations. Once statements exist, prosecutors gain leverage. They offer deals based on perceived strength. Even weak cases look strong when statements exist. This pressures people into pleading, not because they are guilty, but because the risk becomes unbearable. Fifth, your words affect sentencing. If a case reaches that stage, early statements are revisited. They are used to argue intent, awareness, state of mind. A sentence spoken casually can reappear years later, not as explanation, as proof. Another pattern most people never see. Your words influence how you are treated. Cooperative people are questioned more. Police return to those who talk. They push further. They dig deeper. Silence often ends contact. Talking invites continuation. Another pattern is escalation. Small statements lead to follow-up questions. Follow-up questions lead to new areas. The scope of the case grows. What started as clarification becomes investigation. Another invisible effect is memory locking. Once you speak, your memory freezes. Later, when you recall events differently, your growth looks like deception. The system does not allow evolution. It expects consistency across time. And humans do not work that way. All of this happens without drama. No shouting, no threats, no violence. Just process. That is why people are shocked later. They say, I only talked because I thought it would help. It did. Just not you. The sentence did exactly what it was designed to do. It created structure, reduced uncertainty, accelerated decisions, at your expense. This is why lawyers say, the interview is the case, not the trial, not the verdict. The interview, and that one sentence is often the beginning of everything that follows. It is not dramatic. It is efficient. And efficiency is what systems value most. In the end, the lesson is simple, but uncomfortable. The legal system does not reward honesty. It rewards control. Not control over truth. Control over information. The moment you speak, you give that control away. You believe you are explaining. The system believes it is collecting. You believe you are helping. The system believes it is building. And once the building starts, it rarely stops. That one sentence, I just want to explain what happened, feels human, feels reasonable, feel safe. Legally, it is none of those things. It opens a process that does not pause for intent. It does not slow for innocence. It does not care how fair you feel. It cares how usable your words are. The system is not personal. It is procedural. Procedures turn speech into records. Records turn records into leverage. Leverage turns leverage into outcomes. And outcomes do not ask what you meant. They ask what was said. Most people learn this too late. They learn it when a report contradicts their memory, when a charge surprises them, when a lawyer says, "You shouldn't have said that." By then, the record is closed. The truth they carry no longer matters. Only the version that exists on paper does. This is why silence matters. Silence does not create leverage. Silence does not freeze mistakes. Silence does not lock you into a story you cannot escape. Silence forces a system to work without shortcuts. It forces evidence to stand on its own. It slows momentum. And momentum is what hurts people most. Silence is not about defiance. It is about timing. There is a moment when speaking is dangerous. And that moment is the beginning. Before rest, before clarity, before counsel. That is when words do the most damage. This is why the most powerful sentence you can say is the shortest one. I choose to remain silent and want a lawyer. That sentence does not accuse. It does not explain. It does not justify. It protects. The system understands a sentence perfectly. That is why it discourages it. It will tell you silence looks bad. That cooperation helps. That honesty clears things up. These are pressures, not protections. The law gives you rights for a reason, not because you are guilty, but because systems are powerful, and power requires limits. Silence is one of those limits. So remember this. You do not win legal battles by explaining. You survive them by choosing when not to speak. Because once words enter the system, they never leave, and the system never forgets.